Here's what's coming up on today's show.
So there are ways to transfer assets from the dead guy to the heirs without ever having a will or a trust, and avoiding probate as well by just having everything controlled by a transfer on death instruction.
This is the Retire Happy podcast with John Amarino, a fiduciary financial advisor at Securus Financial in the San Diego area, and Thomas O'Connell, president of International Financial Advisory Group, Inc. in Parsippany, New Jersey. Together, they'll be keeping retirement happy from coast to coast.
Welcome, everybody, back to another episode of the Retire Happy podcast. I'm your host on the West Coast, John Amarino, and I am joined by my host and good friend on the East Coast, Mr. Tom O'Connell. Tommy, how you doing, buddy?
I'm doing great, John. How are you?
Good. It's July heat is upon us. How's the weather back east?
Hot and humid, just like a typical New Jersey summer. But all in all, not so bad. I mean, we've obviously had worse, drier summers, so can't really complain too much. It's better than the snow, in my opinion.
Yeah. We were back in New York in Cooperstown the 4th of July week, and we got blessed with no rain. And for the most part, it was like low 80s with just towards the end of the week, it got humid. So, we were kind of blessed with some weather out there.
And Jake the Snake had a good weekend out there.
He did. He threw his first no-hitter in a very coarse field environment. He threw a 5-inning no-hitter. They ended up rolling him in the bottom of the 5th, but you had. I think we averaged 3 to 4 home runs a game, and he only let 2 balls leave the infield. So it was a big. He didn't get his first home run that he wanted, but he got the no-no, which was even better. So
nice.
Good things. And he's got one more year there. So, well, folks, on today's episode, we have a phenomenal topic. In the past, we've brought on good estate planning attorneys, and we've talked about the importance of having a trust, but Tom, we've never talked about settling the trust. And today's guest, he's a member of my virtual family office as one of the experts that I have access to, and I had the chance to really just kind of sit down with Josh at lunch and talk, and then heard him speak. And phenomenal speaker, and even as a retirement expert, we're always learning new things, right, Tommy? I mean, for as long as we've been in this, it's an evolving landscape, and Josh even opened my eyes to some things that I didn't know about the trust and estate planning landscape. So I'm really excited. He's a great speaker. I think everyone's going to really enjoy it today. And Josh he's a simple guy, Tommy. He lives up in Santa Barbara here in California. And when we were talking, Tommy can attest to this. I said, Josh, what do you want me to talk to you about? He goes, just tell him I'm an expert estate planning attorney. Simple enough. You can put my bio in the notes. So, without further ado, I'd like to introduce to you our guest expert, Josh Yager.
Introducing today's guest from Anodos Advisors, the managing partner, Josh Yager.
Hi guys, it's Josh from beautiful Santa Barbara, California. Looking forward to a fun conversation about death and what happens to one's money after that.
Yeah, that's a great uplifting way to start the show, Josh.
Yeah. Keep it real, baby.
So before the show, when we were kind of discussing the show, Tommy, of course, always going to bat for people in New Jersey who just have things a little bit differently. So we're going to let Tommy kind of kick this off on the New Jersey side as we try to cater to everyone here across all the different states. So Tommy, why don't you lead things off here?
Thanks, John. So, Josh, the first thing that comes to my mind when we talk about estate settlements is here in New Jersey, we have actually a fairly simple probate system where you don't need representation if you don't want it, type of thing like you do in California, Florida, some other states. So why don't we start off for the audience just talking about just the difference between what probate is and then how trusts come into play and what that does for the probate system.
Cool. That's a great question because probate has become a bugaboo or the chief sales tactic for trust and estates attorneys.
Right.
You want to avoid probate at all costs. Is the thesis. I'm not so sure that that's true. I'm certain that it is jurisdiction specific. There are some areas that have some states that have adopted very easy probate processes. The distinction is probate is what happens if you haven't set up a trust. So it's the stuff, the estate that the dead person owns. And so you don't have to go through the hassle of retitling houses into trusts, retitling business interests into trusts, retitling insurance into trusts. You just say, look, dad died. Whatever dad had when he died, irrespective of the titling, is part of dad's estate and now has to go through the probate process. Now, practically, the steps of probate, the things that one has to do, are the exact same things as a trustee has to do within a trust. A trust is just the settlement of the estate without a judge looking over your shoulder. So you can do it on your own time, whenever you want, with or without legal support. So
much
one of
more
them
private.
Yeah, so the protection of identities and having the process be free from public view is the pitch of why you should do a trust. Also, some jurisdictions, it's kind of more expensive. In California, the statutory attorney's fees for doing probate are really, really high. And so there can be fee reasons why one would not want to do probate. But practically the steps in the settlement of a probate versus the steps in the settlement of the trust are the exact same steps. You have to marshal the assets, which means identify what the heck the dead guy had either in his estate or in the trust. You have to give notice to beneficiaries that, hey, grandpa died and there's stuff coming down. Are we cool with this being the correct will or this being the correct trust? Payoff of any debts that are owed and ultimate distribution of the assets. In one case, you got a judge looking over your shoulder. In the other case, you don't.
Now, Josh, can I stop you really quick right there? Now, to get to probate, though, right, can we just really quickly go over the difference between, and you know, we're talking you have a will. Because if you don't have a will, then you're intestate. And can you just quickly talk about that?
Yeah, so if somebody dies and they have stuff, let's keep it really simple. Dad dies and he's got a house. And say that's the entire estate, it's the entire transfer of assets. Option A, dad never did anything. And he never wrote any testamentary instructions, never wrote a will, never did anything. He just died. So he dies intestate. What has to happen with that house to transfer title to the kids so that the kids can sell it? The answer is you got to go through probate. Second option, dad did something about it. He went online and did a do-it-yourself will, or he had his local attorney draft up a will for him. You got to go through probate. It's the same process. You're not dying. Intestate means I haven't expressed what I want to have happen with my money. And so there's this interim step of, well, who gets it? If dad didn't say who gets it, then we have to ask the question, who should get it? Is there a surviving spouse? Is there a surviving parent? Are there siblings? Are there children? Are there grandchildren? And there are rules around intestate succession. What happens with your money if you never wrote a will and then the state decides for you who gets your dough? That's option A, through the probate process. Option B is dad wrote a will and said, I want it all to go to my one granddaughter. Okay, he's now expressed who gets it, and it goes through probate again if it's through a will. Third option is dad goes and gets his local attorney or goes online and fills out a trust and has a trust document, and then he goes through the step of transferring title of the house into the trust, and the trust says it goes to my granddaughter. Great, that's the third approach. Fourth approach is dad goes down to the county and files a transfer on death deed, a TOD deed, which says at my death, this house transfers to my granddaughter. That instruction in a deed is a transfer outside of probate, outside of the trust. It happens by operation of law, and it goes straight to the granddaughter. So those are kind of the four ways that you see assets transferring from the dead guy to whoever the inheritors are. And 100% of all assets have to go through that process. It doesn't matter whether dad has been proactive and had somebody write up a trust for them or a will for them or did nothing. They're going through probate or they're going through a trust settlement in either case, because the title has to change. There has to be some record of who now owns this Morgan Stanley account, or who now owns this IRA, or who now owns the house. And so those are the processes. And whether he has got an estate plan or not kind of doesn't matter. There is going to be a probate settlement. It's just an intestate probate settlement.
Okay.
Now, anything that's named as a beneficiary, any asset,
anything that has a beneficiary name, a convention, is what's called a non-probate asset. Right. It can't go through probate. For example, dad's IRA. Let's change the hypo and say dad has a house and he's got a $250,000 IRA at Vanguard. That IRA can't go through probate. It's possible that dad writes in his will, I want my granddaughter to get the IRA. It doesn't matter what dad wrote in his will. The will doesn't have power over a non-probate asset. Or dad writes in the will, I want my son to get the house, but dad has already filed a transfer on death deed that says granddaughter gets it. Doesn't matter what he wrote in the trust document or the will. The definition of a beneficiary with some identified and standardized approach, either with a transfer on death or a beneficiary form on an annuity or an IRA or something like that, trumps whatever language there is in the document being either a will or a trust. And it transfers free of probate and free of trust. That doesn't mean it's free. That doesn't mean the cost to transfer it isn't free. It just means that there is no probate process because it's a non-probate asset when you give a beneficiary on it. So you can potentially do estate planning with very large assets without a trust document or a will at all. If the assets are liquid, you set up the Schwab account and have a transfer on death designation, or all the assets are in an IRA, or all the assets are in a second to die life insurance policy, or there's a transfer on death deed. So there are ways to transfer assets from the dead guy to the heirs without ever having a will or a trust, and avoiding probate as well by just having everything controlled by a transfer on death instruction.
Wow. That's good to know.
Yeah.
So Tommy, did that answer all your stuff over there in Jersey?
So far.
All right.
I'm sure I'll come up with something else.
I want to bring something to your guys' attention that is kind of new for me, a new learning. The pitch that my colleagues make is you got to draft a trust document because you want to avoid probate. And by avoiding probate, you don't have the public scrutiny and you don't have a judge breathing down your neck. There's a couple of reasons why I'm seeing that pitch backfire. Because what it means is the successor trustee, if you go through the exercise of going and hiring the estate planning attorney and paying them $3,000 or $5,000 for the cool binder that says, okay, now you got a trust document. The effect of that is there aren't any timelines. There aren't any due dates. If you're in a court overseen process, the judge says, look, you've got 4 months to tell me what assets are owned by the estate. We've got 1 year to settle the estate. We've got 6 months to provide notice to creditors. In a trust settlement, as distinct from an estate settlement, there is no accountability like that. So I'm seeing the settlement of trusts drag on really, really long, much longer than probates, because there isn't any third party saying, look, we got to get this damn thing done. I also see them drag on a long time because the drafting preference for almost every grandpa in the country is I'm going to name my surviving spouse as the successor trustee. That's if you've got a trust. Or the executor of my estate. That's if you have an estate, a will. And those people don't know what the heck they're doing. They're usually like a grieving widow that doesn't have a fax machine or email. And the entire administrative process of transferring the assets from grandpa down line is totally jacked up right now because the people being named as the successor trustee are trusted by the dead guy, but they have never done this job before, and they don't know what the heck they're getting into.
And it's a lot of work.
It takes me for a $5 million estate to settle, which is kind of my bread and butter. My business focus is on the $10 million and less market, because that's the cohort that all of the big law firms have forgotten. You can't make much money on a $10 million and south estate settlement. It takes me about 30 hours. When I say me, it's not just me, it's my team, about 30 hours to settle a $5 million estate. That's pretty vanilla. So if you don't have me or somebody like me standing by grandma as she's trying to muddle through closing accounts and figuring out what to do with the IRA and figuring out what to do with the apartment building, etc., let's just say it's 2 times that in terms of time without somebody that knows what the heck they're doing, just the family muddling through. Whether it's a probate, that's a judge overseen process, or whether it's an estate settlement. There's just a lot of time and BS. Valuations have to be done. The financial institutions right now are an absolute nightmare, and it's going to get worse because the demographics suggest that the current mortality rate on the baby boomers is going to go 2x in the next 10 years. Right now, about 3% of the baby boomers are dying per year. In 10 years, it will be 7.5% or 8% of baby boomers. So like Schwab, Fidelity, JP Morgan, Wells Fargo right now, these are all institutions that I have active cases with where I'm screaming at them once a week. Why hasn't the IRA transferred? It's really simple. I got a copy of the beneficiary forms. It's clear where these assets go. And they're like, oh, it's been accelerated into our estate settlement team. And it's like, why? Well, really, the reason why is they're understaffed and a higher than expected number of their clients died. And these institutions are getting locked up. It's routinely 4 to 6 weeks to get an institution to make a call on something that on its face is really obvious. Beneficiary of dad's IRA is X. Mom's account's already set up. Let's go. Oh, we got to go through our compliance department. Where my experience was 10 years ago, that was like a 2-week process.
From a cynical standpoint, right? I guess statistically speaking, I think 2 out of every 3 beneficiaries don't use the same or get a new advisor that, say, mom and dad had, right? So now these companies that you're talking about are losing assets, and they don't want to because that's where they make their money. So from a cynical standpoint, I find that sometimes it just seems like they drag this out so they don't have to let go.
Right. If they can delay by 1 quarter, they get 1 quarter's more revenue on 12B1 fees or whatever fee agreement they have. And that's true, Tom, both at the custodian level, Schwab, Fidelity, and it's true at the RIA level.
Right.
The investment advisor who uses Schwab or Fidelity. I'm not saying the investment advisors are delaying because the investment advisor really doesn't have much of a role in the time to transfer title. It's really the institution's back office, but the investment advisor is at risk, right? As soon as you hear that one of your clients died, you know that there's a clock ticking. I better freaking get in relationship with the inheritors, or I better find a way to add value for them, because the risk is that those inheritors already have a relationship with somebody else that's chomping on the bit to have the estate settled so they can get the AUM from grandpa that you currently manage. And there's a whole bunch of tangles here. This is crazy. So one observation is we know the money is in motion as soon as grandpa dies. Somebody's going to win that game. Somebody's going to lose that game. It's a zero-sum game because it's a fixed amount of money. 2 observations. One is the RIAs can help keep the assets sticky if they have helped their client prepare for their death. In other words, the eldest son from another state that doesn't have a relationship with the RIA, if he steps into this and the RIA says, look, good to meet you. We knew this day would come. We've already prepared everything. This normally would take you 60 hours. We've gone through a process of pre-settling the estate, reviewing everything, archiving everything, coordinating mom and dad's financial and legal affairs so that we can help pass the baton to you. And the inheritor, the successor trustee, or the executor is going to be like, dude, this is a high level of service. Thank God that John and Tom took some time to help prepare this estate so that my job as a doctor or an architect or whatever the inheritor's job is going to be easier because I got someone in my corner helping me do this. That's one observation. We in the professional services community can do a better job of pre-planning the settlement in anticipation of somebody that we don't know is going to get the baton. Second observation, many of the existing clients of RIAs are beneficiaries themselves or inheritors themselves. And in many cases, they're named as the successor trustee. So you two guys have clients right now. I'm going to say it's the 55-year-old engineer who's the only smart kid amongst his siblings. And mom and dad named the 55-year-old engineer who's your client as the successor trustee, and you have no idea that that's true because you've never asked him. Are your mom and dad still alive? Have they set up an estate plan? Are you the successor trustee or executor of that estate plan? Are you prepared for that day when you have a second job besides doing engineering? And they're going to be like, no, I don't know what you're talking about. You can help mom and dad and your own client do that same preparation. So I think there's a huge opportunity for value add in this kind of pre-settlement diagnosis of what is going to delay the settlement, or what is going to increase the cost of the settlement. And while mom and dad are still alive, let's fix it. Why shouldn't we fix it?
Right.
It's not that hard to do. I mean, all of us have been involved in settling estates. We know where the toes are going to get stubbed. We just need an hour with mom or dad ahead of time to help eliminate those loose ends and just go through a quick inquiry checklist. Bing, 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 bing. Now, what I was sharing with John at the conference was, look, I'll give you guys the checklist. Like after this call, I'll send you the checklist of here's all the things that you should ask your client about, whether they are the settlor, whether they're grandpa, or whether they are the inheritor. They're the 55-year-old engineer. These are the questions. And you guys are eminently qualified to solve these problems. You don't have to be an attorney to ask the question, where's the safety deposit box? Because I don't want my client to be driving all around town looking for a safety deposit box. Or what do we do with the gold coins? Or somebody should pull the deed on the house and make sure it's in the trust, right? Those kind of things are pretty, that's like a 1 hour, once a year inquiry process that can be gone through. And my encouragement to the professional services community, CPAs, attorneys, and investment advisors is we better get after it because there is a wave of settlements coming like none other, and we are ill prepared to handle it. And we need to be able to settle these estates twice as fast at half the cost with lower risk. And the only way to do that is to untie the knots before they get tied tight by dad dying. So that's what I'm pounding my chest and the phones for is, come on, guys, let's start asking our clients these questions. Now, that's particularly true when you have a client or a pickleball buddy or a guy from church that just got a bad diagnosis. And it's like, dude, his estate is going to be settled in the next 24 months. If I don't ask these questions, who's going to ask these questions? Because the trust and estates attorneys don't ask these questions. And the investment advisors don't ask these questions. And the property managers don't ask these questions. Nobody's asking these questions. And the questions aren't that hard to ask.
Yeah. Yeah.
And that's a great segue, I think, into, Josh, what your service provides, what your specialty is, right? Where you're kind of the facilitator of that for these families.
So what I've done is said, look, God already made enough trust and estates attorneys who are interested in writing trust documents. The need doesn't exist for another smart trust and estate attorney who uses a boilerplate document to write a binder that he charges $3,000 to $5,000 for, that basically has the exact same content as the last client. Writing documents is a very high margin business. It takes about 3 to 5 hours to take a client from first meeting to final meeting in the estate drafting process. The estate settlement process, there are many trust and estates attorneys that write documents but don't settle documents because they see themselves as educators and architects of the plan. They don't see themselves as the blocking and tackling guys that are fighting with Schwab about IRA beneficiaries. So my thesis is, look, I'm going to swim where the ocean's blue. I don't want to be in the place where there's already an established service for drafting documents, particularly when I'm starting to see AI-generated trust and estates documents that are pristine. Now, I know my colleagues won't agree with me, but the trust and estates documents that are coming out of machine learning are awesome. So that means, okay, they're not adding that much value by find and replace John Smith with Tim Jones in the trust doc. So the need is on settlement. The grantors are naming their family members as the successor trustees. Maybe 50 or 75 years ago, they disproportionately named banks as the successor trustees. Maybe in the mid part of the last century, 70% of trust docs named a big regional bank as the successor trustee, and the banks, for whatever reason, lost their way and realized AUM makes more money than settling trusts, and so they raise their minimum and raise their fees, and families say, I don't want to be treated by a bank. I want my eldest son to do it. Eldest son's got a day job. He doesn't know how to do it. It's a pain in the neck. The nephews and ticked off siblings are chomping at the bit to find instances of where he hasn't done his job well so they can bounce him so that they can be the trustee. And so I've gone to the blue water, which is I'm going to be a trust and estates attorney that has never written a trust or estates document. All I'm going to do is settle trusts. So our service began with settling trusts, and then I stubbed my toe on it enough times thinking, doggone it, I wish I had talked to Grandpa 1 month before he died, because I would have had him sign this piece of paper that would have made the ultimate administration twice as fast at half the cost. So then we started the kind of pre-settlement, we call it the estate vault. It's reviewing and coordinating and fixing any gaps in the financial and legal documents and putting it in an encrypted vault and including the kid, the successor trustee or the heir apparent executor to that vault so that when dad dies, everything's teed up. So estate vault service, pre-death, estate settlement service, post-death. And in some rare cases, the trust doc says, after grandpa's died, go through the process of marshaling the assets and paying off debts and providing notices and all the stuff. And at the end, rather than cutting checks to everybody, cut checks to a long-term trust, a generation skipping trust or some other type of trust design, a Q-tip trust, maybe if there's a blended family. And then that trust exists long-term. So the last service we have is ongoing governance for the trustee after the settlement has happened, because the trustee doesn't know what their job is, and usually there's an adversarial relationship between the trustee, who's the third wife, and the beneficiaries of the trust, who are the kids from the first marriage. So the service is make sure you don't screw up because you have a likelihood of being sued. So those are the three services. And some clients engage us for everything. Some clients engage us for one. I don't really care. I get paid the same either way.
And one thing I liked in the conference where you're talking about, your process is you're like, not saying that all attorneys would do this, but there's always that guy in every industry. And, they're getting paid hourly, so let's take our sweet time and just drag this out because I'm getting more money and, I'm providing a service, but, the hours is what I'm getting billed on. You're a flat rate, so you're like, hey, I'm getting, to a certain extent, a flat rate.
Yeah.
Let's get this done efficiently so everybody gets their money. I move on to the next client. You guys move on with your life, and the trustees, as you said, concentrating on their day job, and everything's just done with efficiency, not
So if we start off, John, with my thesis, which is all of us, trust and estates attorneys, investment managers, investment advisors, CPAs, all of us in the professional service world, we better get ready. We better figure out how to settle trust twice as fast at half the cost with lower risk because the number of trusts that are going to hit our plate are 2 or 3x what they ever have been. Okay, so that's just me calling the shot. I don't care how we do it, we got to do it. As I reverse engineer that problem, one of the things I observe is, one of the many things that has to change is we've got to move away from the hourly rate model, because the hourly rate model doesn't reward speed. Let's say that John is a trust and estates attorney and he's really freaking fast and he charges $500 an hour. And I'm a trust and estates attorney that isn't really freaking fast and I charge $400 an hour. If John exercises his mastery of the craft, he will get paid less money than I get paid, even though I'm less good at the job. So that's true of CPAs and attorneys. They have chosen to be paid an hourly rate. God bless them. Let them do that. They can do whatever they want. It's their business, not my business. But as for my business, in order to accomplish the twice as fast, I better be rewarded for being twice as fast. I don't want to get paid half for being twice as fast. So I say, look, I got a fixed fee. If it's the estate vault process, the pre-death process, I don't care if it's a $10 million estate or a $1 million estate. My fee's $3,000. If it takes me 5 hours to do the work of reviewing the trust doc and changing title and doing all this stuff, that's fine. If it takes me 10 hours, 20 hours, look, I made my deal. I said it's $3,000. So that's what I got to get it done in. If it moves on to the estate settlement process, most trust and estates attorneys will help grandma settle the estate. Most of them will charge an hourly rate. Mostly that work will be farmed out to paralegals and staff because the attorneys can make more time drafting docs than settling docs. And the hourly rate on most paralegals is in the $250 to $350 range, depending on where you are in the country. And those paralegals are also 55 and 60, and they're leaving the practice. So there's fewer and fewer service providers for the settlement. My thesis is, look, let's get away from the hourly rate. We know that it's a $5 million estate. We know what all the task lists are to settle the estate. We know that there's a house and an IRA and an apartment building, some syndicated real estate deal and some gold coins. All right. At the very beginning, we already know how long it's going to take because we've seen all these projects. So why don't we just quote a fixed fee? It's $15,000. It's $3,000 per million. That's the fee. If it takes me 3 months to settle the estate, that's the fee, and I win. If it takes me 3 years to settle the estate, that's the fee, and they win. But by having the fee set, it makes everyone think differently about how are we going to actually do this thing. We can't follow the old traditional approach to settlement if the fee is not the old traditional approach to fee.
Yeah.
And I think this is really important. I love my colleagues in the trust and estates business. Fundamentally, they are educators. They would have done just as well had they got a PhD in European history and were teaching at junior colleges, because they love educating. They love sitting at the whiteboard. They love thinking about, well, what are the tax consequences? And what about this? And covering all of the what if scenarios is why we end up with 35-page trust documents, because my colleagues think that way. And I don't want to get on them and say, oh, they're being self-serving and they're intentionally manipulating the hourly rate process. I don't think that's true. I think God just made them this way. They take a long time. They're risk avoidance tendencies. They're very, very detailed people. They're very, very thoughtful and want to serve their clients well. And it happens to be they got into a business that for 2,000 years has been an hourly rate business. All right, that's not on them. But the consequences of that are it's going to take a long time to do something that should take a short time.
Yeah. Now, Josh, you brought up, the point of a lot of attorneys do more drafting, but will help settle an estate. And I know a lot of our listeners, they have wealth and they know that, they want the proper process of getting the living trust done and, making sure they have their healthcare directives, power of attorneys, whatnot.
Right.
Now, can you talk about if your mom or dad were clients or listeners out there and they said, Josh isn't an estate planning attorney, what would you tell them to go? How would you tell them to approach an estate planning attorney? What are some things that they should be looking for, not only in the drafting, but more importantly, like you said, the settling part?
Well, it really depends, John, on what the estate is like. And let's keep it really simple and say there are estates that should be pretty simple to settle and the estates that are going to be more complex to settle. There's a bunch of factors that go into each of those buckets. Simple to settle would be there's only one beneficiary or the two kids get along fine. But if there's a whole bunch of beneficiaries or one of the kids is a black sheep that smokes dope and lives with mom in the house that has to be sold to settle the estate, it's going to be more complex. So part of it is size of the estate, but my experience has been that the delays are not from the size of the estate. A $50 million estate can be settled in the same time that a $5 million estate can be settled. It's non-financial considerations cause delay. So the things to be looking for are, one, does this person that is drafting the document for me, do they settle trusts? Are they going to be available to hold my spouse's hand or my kid's hand and walk them through the settlement process? And you don't want to ask the question, do you settle trusts? Because everyone will honestly be able to say yes, because they will have settled some trusts sometimes. Or they'll help settle the really high value trust in which they get a really high value fee. But asking them, what portion of your revenue comes from trust drafting versus trust settlement? That's a pretty simple question. I can tell you already, if the practice is kind of a solo or small practice with one or two attorneys and a couple of paralegals, that firm does not settle trust routinely because they've got too much work in trust drafting and they don't have enough staff in trust settling. So they may say, maybe 10% of our revenues from the settlement of trusts and 90% from trust drafting. That's because the demand right now is trust drafting, because the baby boomers haven't done a good job of documenting what's supposed to be done with their estate, and they're starting to freak out and they're starting to retire and they're starting to think about, geez, I really need a trust, don't I? I need the binder. So the work and the high margin revenue right now, the press from the market is you got to be a drafter, not a settler. Other things, ideally, is don't hire someone that's your contemporary. Because if you are 65 years old and you hire an attorney that's 65 years old and you ask the question, are you going to be there to help my widow? What do you think the answer is? Yeah, of course I'm going to be here forever. I'm going to work till I'm 90. No.
Yeah.
You have to hire one entire generation younger than you so that they're around. Now, here's the problem. All the really smart people that got out of law school or got out of college in, let's say, 2000 and beyond, they went to work for Amazon and Google. It used to be, if you were really smart and went to college, where are you going to work? I'm going to become an attorney or I'm going to become a doctor. Those two industries, it turns out, aren't that fun. And the revenue from being those professions is less than being a computer science engineer. So the smartest and the brightest over the last 20 years have not gone into law or tax, and those professions are having a hard time growing and replacing the guys that are retiring, which exacerbates the problem. Who's going to be there to help?
And even, you talk about, I haven't seen it too much or heard about it too much in the financial services and in the advisory industry, but there's a lot of talk that same issue is in the CPA world.
Oh, it's massive.
Yeah.
It's massive. In California, they have admitted half of the new CPAs as they did 20 years ago, this last year, in 2023. They admitted half. My CPA, who I've had for 25 years, retired this year, as did 3 of his other partners in his 15-partner practice. Like, they're all leaving. Their wives are saying, dude, when do I get to go on vacation? Same with the trust and estates attorneys. When do we get to retire? I call that the orphan settlement, where somebody wrote the trust doc, went through the process, got the great book. Book's been on the bottom of dad's filing drawer for 10 years. Nobody's looked at it. And then dad dies, and somebody pulls out the binder and looks at the business card and calls that number, and that number isn't a number anymore. Because the guy that dad had draft his document was his golfing buddy or the guy he went to church with. And that guy is either too busy or he's retired or he's dead. So I call that an orphan settlement. It's not by anyone's bad act or malice that grandma is left holding the bag. It's just by life happens. The guy that drafted the attorney was dad's contemporary. Dad died, ergo, dad's contemporary is probably also not in practice anymore. Who is going to pick up the baton and help this family settle it? And that's the blue ocean that I've decided to get into. I want the orphans. I want the moms that are like, I don't know where to go. Let my colleagues who say, I want to help mom settle the estate or trust, or I want to help the eldest son settle the estate or trust. God bless them. There's so much work out there. There's so much freaking work out there. If the family's existing attorney is willing to do the work, by all means, have them do the work. If there isn't anyone available, call Josh, because I want to settle the trusts twice as fast at half the cost with lower risk all across the country. I want to be the H&R Block of trust and estate settlement. I want to work with the poor people, poor being in air quotes. $10 million is poor? No, $10 million is not poor. But it is routine that trust and estates practices will turn away settlements of $10 million because they're dealing with $20 or $30 million settlements, and they're knocking down 50 basis points or $500 an hour to get the settlement done.
Right.
Yeah, I think a lot of people, to that point, I think a lot of people underestimate their net worth because they don't think about, okay, hey, my IRA or my 401k might be part of this, the equity in my house. Oh yeah, that life insurance policy I had, or the that big term group policy that I have at work. So I think people are, and I'm using some air quotes, wealthier than they think they are because they don't understand everything that goes into it.
And Tom, that's the first step in my mind of the estate vault process, the getting ready for dad to die. Let's do some work. Step one, do a balance sheet, because the estate settlement process is about the estate. We have to define what is in the estate that dad owns, whether it's a non-probate asset or a probate asset. We have to put our arms around, okay, what's all the stuff that dad has? Also, I used to be an investment advisor for 15 years. I gathered assets and did financial planning. And my experience was that the last 10 years of my clients' lives, so let's say 75 to 85, they spent way less than I projected they would spend. Mm-hmm. I'd have in there, okay, I think they're spending $200,000 now, and all inflation adjusted that. They weren't experiencing the inflation adjustment that I was projecting in their spend in the last 10 years. And their assets performed better than we were projecting. We have in there, we're gonna assume an inflation plus 3 long-term return on the estate, and it ended up being inflation plus 5 or inflation plus 8. Because leveraged real estate went up in value, even a modest value, 5% return on leveraged real estate is really 10% if you got 50% debt to equity. Or your stock portfolio goes up, or your fractional interest in the syndicated real estate hotel down the street goes up, or your local stock in the local bank that you participated in the 80s went up. So these net worths are surprisingly bigger than the family thinks when you go through the exercise. So step one is you got to do a balance sheet, and you have to get what I call a source of truth for everything on the balance sheet. Because when grandpa says, yeah, I got an IRA at Vanguard and I think it's worth $300,000, I'm like, I don't believe you. I want to see a statement that says what it's worth.
Right. I think, correct me if I'm wrong, but step 2 is going to be, okay, how are these assets going to be distributed, right? Is my son over his heroin addiction? Is my daughter-in-law still spending money, like
what?
Poo through a duck, right?
Right.
All that kind of good stuff.
My process I'm not saying that my process in the estate vault is right, but my process is you start with the balance sheet, then you hear what the client's objectives are. Just ask them about their kids and their church and what they want and their grandkids and get them talking. then read the trust doc itself and say, look, change the 35-page trust document into a 2-page memo. It says, I don't expect you to read this 35-page document, but I'm going to recite for you in plain language that a 5th grader can read and understand of what happens to your dough when you die. And then you can compare the actual language of the trust doc to what they just said they want or the concerns they actually have around their estate. So you need to create that kind of compare and contrast of what the trust doc actually says that was written 10 years ago or sometimes much longer ago than that with a few modifications, amendments to the trust. And then that can tell you, hey, we do need to amend this trust. There's language that we have to fix here. Then you go through the identification of the non-probate assets, the things that everyone thinks, oh, Dad's got a $5 million estate, and it's divided 2 ways. So obviously the 2 boys are going to get 2.5 each. But some of the assets are not trust assets. Some of the assets are non-probate assets that transfer by a beneficiary form, and oh shoot, we still have the spouse from the first marriage as the IRA beneficiary on this thing. You don't know that's a problem unless you have on your checklist, pull the beneficiary forms because I don't trust what Dad says the beneficiaries are. My experience is probably 1 in 10 or 1 in 15 times the beneficiary isn't what the owner of the account thinks it is. Another thing we got to do is pull the deeds on the house. I don't know how many times they think, oh yeah, the house for sure is in the trust. It's like, all right, great. I'll mark down to check in on that. Pull a deed on the house and actually see what it says. It's probably 1 in 10 in my experience that the real property, apartment building, house, vacation house in another state, is not vested the way you would think it should be vested. And while Dad's still alive, we can fix it. But if he's not alive, okay, we got to probate in Oregon because nobody thought to pull the deed on the Oregon house.
Now, how often, if you do have the deeds on the record, you shouldn't have to do that anymore,
No,
right? Just have
no.
have that copy once
Yeah.
you got it done. Have it in your book though, ready to go.
Yeah, same with the IRA beneficiary forms. Like those things don't change.
Right.
Vesting on the house doesn't change. Balance sheet does change, but isn't that dynamic? Like year 1, my clients ask me all the time, okay, I did the estate vault, Josh. Do I have to pay you next year to do it again? And it kind of depends on how old the client is. If he's an old guy, I'd say, don't worry about it. Have your spouse call me when you die. Because it's going to happen in the next 5 years, and as long as you don't go and start changing title on things, it should be fine. Should be enough breadcrumbs just to cut the time in half. If the client is younger and they've got a more dynamic estate, which means larger net worth, then it's like, maybe we'll do a spot check next year or every other year, charge you half of what we normally charge $1,500 every other year rather than $3,000, because we already did most of the heavy lifting in year 1.
Now, Josh, kind of going on that, if a listener is saying, well, man, I really want this, but then now I'm going to pay them a settlement fee on top of. Do you ever, is the settlement fee and the vault, are those 2 separate entities, or do you ever kind of like combine and say, hey, well, listen, you were a client in the past because you did all this, my job's a little bit easier, or is it just flat fees on both?
No, they are separate services, because I don't believe everyone that buys the estate vault should also hire me for the estate settlement. Because the incumbent, sometimes when I'm doing the estate vault work, I'm doing it on behalf of the drafting attorney who's still around, who still wants to be a part of the settlement of the estate. So I'm like, look, there isn't an orphan settlement here. I'm just doing this work to help out my colleagues in the tax and financial services industry to have a fast settlement for their client, to be the heroes. Now, what I do say to the clients at the end of every estate vault process is, look, if you end up in the place where there's no one to help, call me, because I am now equipped to help. And I will knock off that fee from the first year, the first $3,000, off of my settlement fee, because I've already done the work. Like I don't have to check the deeds because I already did it. I know where the IRAs are. I've got the balance sheet. I know where the safety deposit boxes are. I know what to do with the coins because we already asked the question. But there isn't a presumption that if they hire me for phase 1, the estate vault, they must hire me for phase 2. And there are some instances where clients hire me for phase 2 that never did the estate vault because I didn't find them in time. So right now, of the active settlements that we've got, only one of them out of 10 ever did an estate vault.
Right.
All right, that's okay. Just means my job's a little harder, but I'll still get it done for $3,000 per million.
Right.
On the settlement side. But ultimately, they go together. They clearly go together. But there's no contractual obligation. The most that I'll say is, look, if you hire me for the estate settlement, I will reduce that fee by what you already paid me to do the estate vault. But you don't have to use me for the settlement. You might not even need anybody. It might be that you have a house and an IRA, and all you need to do really is file a transfer on death deed with your county, and there won't be any estate settlement. House will transfer, and IRA will transfer outside of the estate. No sweat. You don't have to pay me $12,000 to do that.
Right. Well, man, it's been 50 minutes. Can you believe that?
What the heck?
I mean,
we crushed it.
Yeah.
And it sounds like we barely touched the tip of the iceberg, it seems like, even.
Well, here's the things that we didn't talk about, Tom. So I think we outlined the big problem. Lots of baby boomers dying, crazy amount of assets. Guys, $90 trillion of assets is anticipated to transfer in the next 20 years. All stocks in the United States, all stocks, Russell 3000 is like 30 trillion. Like, the amount of money that we're talking about is colossal. And every single dime has to go through an estate settlement of one sort or another, whether dad wrote a will or not. It doesn't matter. And like I said at the beginning, it's a pain in the neck either way. So it's going to happen. And there are fewer professionals that have fully engaged with this massive train wreck of a problem that's coming down the road, which means we don't have to be that smart to add massive value because nobody has decided to play in this sandbox. And that's what I want to do. I want to be the guy that is a champion of this sandbox, equipping RIAs, CPAs, trust and estates attorneys, and families to do this right. And if I just play in that area, I'm going to make a bunch of money and do good in the world.
Right. Well, with that, if you're looking for this type of service, the estate type of vault, or the settlement.
Yep.
And you're a listener, you can always contact Tommy and I, or Josh. How do people get a hold of you direct?
The website's easy to remember: trustee-help.com. That's also my email, josh@trustee-help.com. Look it up. Shoot me an email. Schedule a Calendly call. I'll shoot straight with you on whether I can add value or not.
And
what I don't want calls for people saying, "Will you help me write my trust doc?" Because I don't do that. There's plenty of other attorneys that do that. Go with somebody local or buy one online.
Now, are you? Let's say obviously you're in California, but you got one of Tommy's clients or a listener in Nebraska. What are you barred? Can you do this everywhere?
Yeah. The issue is where are you licensed to practice law, A, and is the settlement of an estate practicing law? So the vast majority of my time on an estate settlement, so forget about the estate vault pre-planning. Clearly that's not practicing law, apart from maybe reading the trust doc, which is a wobbler issue. But on the estate settlement, it's messing with counties around vesting of deeds. It's messing with Schwab around IRA beneficiary forms. It's figuring out how to sell grandma's jewelry. It's figuring out who gets the convertible 64 Mustang. Like, it's not legal work. It's blocking and tackling. So I'm only licensed as an attorney in California. And when California clients engage me, I usually say, don't engage me as the attorney because you don't need an attorney. You need a secretary to take things off of the checklist. And if we ever find ourselves in a gray area, if you're not in California, I'll find you an attorney to give you very pointed advice on this pointed issue, noting that I am an attorney and I know how to engage those people on fixed fee engagements and narrow the scope. Or if they're in California, I'll just do a side hustle agreement with them and say, look, I'll charge you $500 for this stupid thing that I have to be an attorney to do. But my preference is I don't want to be the attorney Because the need isn't legal services. The need is complex project management for projects relating to the settlement of estates, which you don't need to be an attorney for.
Right. Well, Josh, I think, as Tommy said, and you backed up, I think we're just going to have to have you on again,
Sure.
in the future, because there's just, and, the laws are changing rapidly all the time. And, having guys like you in our corner, Tommy and I have always said we don't, this world and the profession we chose to really focus on the planning, not the sales part of being financial advisors. I mean, when you really branch out, there's so much out there that it's impossible for one advisor to be able to effectively cover everything. It's really about having that team, that power team,
Exactly.
Yeah.
Of experts in their areas to be able to do it. And Josh, you're definitely one of those people. So we thank you for spending an hour of your time and helping our clients and helping our listeners learn about trusts and settlements. So, folks, we hope you enjoyed this show. We thank Josh again for coming on. And Tommy, you got any final words of wisdom?
Not today. I'm kind of at a loss for words. There was just so much information there that I'm still trying to process it. I really look forward to having Josh back on because there's so many other things for us to touch on with this, including how we can be a part of that process for our clients that helps out Josh. Right, makes that job easier, more efficient, and all that kind of stuff. And I know we don't see that in our industry a lot. So,
yeah, it's an opportunity for differentiation for RIAs and CPAs. Is to say, yeah, I'm familiar with the process. I got a team that can help. Some of it I'm going to be doing out of my office. Some of it my colleagues in a different office in a different state are going to get done. But I'm ready to fully engage. I just thought of a follow-up item. I'm going to send you guys the checklist of the things that delay settlements. So it's kind of like a self-diagnosis that you either could go through with your client, or you could throw your moniker or label up at the top and use it as your own. But it's like 20 or 30 questions that are easy to understand. You just go down and score it. Yeah, that's true of my estate, or no, it's not true. And it'll give you a sense of where for this client are the risks, and somebody ought to engage in digging in and identifying what can be solved before mom or dad die.
Great.
So
Awesome.
It's so easy. I don't know why nobody's ever done it before, and I want the world to have access to this risk diagnostic thing.
Well, we'll definitely take that, and we'll also put it in the show notes. So, folks, again, thank you for the resources, Josh. Thank you for your time. Folks, I know so many of you have rental property and business property. Our next show, we're going to be sitting down to talk 1031 exchanges. So we hope you enjoyed today's show. Josh, we're going to see you again in the future. That's our promise. And Tommy, well, you stay cool over there on the hot and humid East Coast.
And you stay whatever you do over there on the West Coast.
But listen, I mean, San Diego's got nice weather, but Josh lives in a beautiful community also. So Josh and I will just enjoy our weather. Yeah. So that wraps it up, folks, for another episode of the Retire Happy podcast. We thank you for listening in. And as always, if you want to hear something that's on your mind, send us a suggestion as to what you want us to talk about. Until next time, folks, retire happy. Take care.
It's easy to get in touch with John and Thomas. If you're more on the West Coast, give John a call at 858-935-6210. That's 858-935-6210, or go online to GoSecurus.com. That's GoSecurus.com. If you're more of an East Coaster, then call Thomas, 973-394-0623. That's 973-394-0623, and online at internationalfinancial.com. That's internationalfinancial.com. And you can, of course, always just check the description or the show notes section of today's show for all that contact information. Don't forget to subscribe on your favorite podcasting apps, and we'll see you next time on the Retire Happy Podcast.
Investment advisory services offered through Brookstone Capital Management, LLC BCM, a registered investment advisor. BCM, Securus Financial, and International Financial Advisory Group are independent of each other. Insurance products and services are not offered through BCM, but are offered and sold through individually licensed and appointed agents. The opinions expressed by John Iamarino, Thomas O'Connell, and guests on this show are their own and are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Investments involve risk and, unless otherwise stated, are not guaranteed. Past performance cannot be used as an indicator to determine future results. Any strategies mentioned may not be suitable for everyone. Information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for you. Before acting on any information mentioned, please consult with a qualified tax or investment advisor to determine if it is suitable for your specific situation. This program is designed to provide accurate and authoritative information with regard to the subjects covered. Registered investment advisors and investment advisor representatives act as fiduciaries for all of our investment management clients. We have an obligation to act in the best interests of our clients and to make full disclosure of any conflicts of interest, if any exist. Please refer to our firm brochure, the ADV 2A Item 4, for additional information.